Well, I'd like to thank you all for coming out, for hearing me ramble on for a little bit. It's kind of ironic that I'm here at Drexel, where 28 years ago I got kicked out of the mechanical engineering program. It seems that they didn't like my rule that said, I got kicked out for drinking because I thought the rule was if it spontaneously turned into beer while it was in my possession, I wasn't bringing beer in. They didn't like that argument. They didn't like that argument much, but obviously it shows why I've picked a different profession. So, disclaimer: I'm not representing the opinions of any of my company's clients or my employer, if I still have one at the end of this talk. I may be a lawyer. I'm not your lawyer. I am, however, a certified information security professional, trademark. So follow that advice if you like. This is for edutainment purposes only. Don't take anything I say with take everything I say with a bit of a grain of salt. If you actually have specific questions, ask me later. So, how does the law affect... Okay, who here is an information security professional trademark? Who here wants to be an information security professional trademark? Okay. Oddly enough, the law affects us. More so than in a lot of other industries, because this is an industry where if a bad day for us can be potentially criminal. Who here has ever pen tested the wrong box? Who here is lying? Right? You find out something's out of scope. That can be a felony. Yeah, like, oh man, I dropped shell on this thing. That's not ours. Oh, oops. Sorry. And there's some sales guy going, hey, maybe we can sell them a pen test. You've already done half the work. Like, no, that's not a good idea. Maybe it is, I don't know. It's, aggressive sales. Okay, so what areas of the law affect us as information security professionals? First, contracts, and I'm going to sum that up. I'm going to sum 3 years of law school into one PowerPoint slide. Contracts, what you agreed to do. Regulatory law, right? It's two people or two companies or, one person in a company decide to make an agreement. They love each other very, very much, and they sign a contract, and sometime later they decided that they really don't like that agreement. Or one side wants out. Well, you have to go back to the contract to figure out what on earth you actually agreed to do. And oftentimes that can determine how you get out of the agreement, or what happens if you don't uphold your side of it. Then there's regulatory law, what you have to do. If you are in healthcare, you're familiar with HIPAA. If you're in financial services, you're familiar with Gramm-Leach-Bliley Act, or really what dribbles out of that is the FFIEC guidelines. And then there's criminal law, what you must not do unless you like going to jail. I used to work as a public defender. Jail is nasty from that perspective, and I got to leave. So, walk through contracts. Basic idea is that a contract is a binding agreement. It's not just a promise, because we break promises all the time. It's both a promise plus a what I'm going to give up if I don't do the thing. It doesn't have to be reasonable. I can sell I could sell my car for $1, which would be thoroughly unreasonable because my wife would probably wonder where my car is, or our car. But there's no judgment whether or not that was a fair deal or not. I could also sell my car for $100,000. And, it's a 12-year-old Saab, so it's not worth $100,000. But the court, if it comes to a dispute, will not say that was an unreasonable deal. Contracts are something for something. I promise to perform a penetration test against your web application. In exchange, you're going to give me all the monies. It can't be one-sided, as in, it can't be, I will do these things and I don't have to do anything on your side. It's some agreement by which each side is giving up something or doing something. There are actually very few limits on contracts. First is if it's actually against the law. If it is unenforceable, as in, I cannot have a contract that says, I get to kill you. I can't have a contract that says, you are going to deliver to me 2 kilograms of Peruvian blue flake. That's an unenforceable contract. For those of you unfamiliar, that's legal. That's, Peruvian blue flag is cocaine. Otherwise known as the pen tester's friend at DEF CON. Great, this is getting recorded, isn't it? Okay. The other is if the contract itself is what we call unconscionable. It is so one-sided that the two parties making the contract, one has all the power, one doesn't. You can sometimes try to void a contract or phrases of a contract by saying there wasn't any negotiation, it was not a fair one. However, the standards are fairly high. You have to, for you to win on that, you basically have to show that the other company had some kind of power over you. There was duress, there was some kind of control over you that forces you to sign that contract. So, just because Comcast has a great deal more power than I do when it comes to the triple play plan, I can't say that the contract itself is unconscionable and unenforceable. Okay, so let's talk about contracts relevant to us. Anyone here ever read an end-user licensing agreement? Damn, more masochist than I am. Those are binding, even though many of the time people don't read them, right? You click through them, but if you actually read through them, are a term of service. And EULA is usually when you're talking about software. A term of service is when you're talking about a web application or a website offering you some service or, X as a service. By using that, by agreeing to that, you agree to, each side gets to limit the use the other may use. You can limit behavior, such as, say for example, Facebook does not allow you to use their systems to harass other members. Twitter has a similar rule, I understand, because they're, threatening to remove our president-elect from it, which would probably make many members of his campaign staff happy. But another would be limit modification. For example, in a EULA or in the software license, I may bar you from reverse engineering my software. I may bar you from using it for certain purposes. If you've ever read the iTunes EULA, you may not use it for running a nuclear power plant. If you find a way of operating a nuclear power plant with iTunes, clearly you're deranged because the amount of, please enter your Apple ID to restart the core. Because it always seems to forget mine. Yet it still holds me as certified as an Apple desktop engineer, which I haven't had that certification for like 12 years. It may limit republishing. Say, for example, if you reverse engineer the code, you're not allowed to publish it. You find vulnerabilities in the code, you're not allowed to tell anyone but the manufacturer. Stuff like that. We can put that in a contract that binds us and restricts the rights we might otherwise have. Another example, for business contracts. Those of you who may end up working for a consulting firm, which will probably be half of you, because right now it seems to be those are the big people who are those are the big groups that are hiring us off out of college. So if you go work for Accenture, Protiviti, or Dell SecureWorks, or some other large shop that just pipeline in, pipeline out, the MSA or PSA. This is a contract that is often the first thing you sign when you engage a consulting firm. It doesn't actually bind either party to paying anything or doing anything. It just says any subsequent contracts will follow these rules. Payment will be on net 30. You have 10 days to accept or reject the deliverable. Stuff like that is in that. It basically sets the ground rules for how we're going to do business. The next one is the statement of work. This is what each side agrees to do. I will pen test this web app named this on these dates for this amount of money. Simple. Because you're relying on all the other boilerplate back in the master service agreement. Once you start doing consulting work, these are your Bibles. When you first get your first engagement, my rule has always been to juniors who have worked for me, read the statement of work. It doesn't matter what the salesman promised. It matters what they signed to do. You will not make their lives easier. You're instead going to give them a 5-page deliverable showing all the vulnerabilities in their app. Have a nice day. That's what you promised to do. That's what you're getting paid for. Do that. Others. Non-disclosure agreement. What you can do with the information you gain during that engagement. And this may limit you. So, how do you enforce a contract? You can file a lawsuit. Say, for example, if one side is not performing to the likings of the other, you can file a lawsuit saying, I demand you either perform what you promised to do, or pay me damages. So, for example, I do a pen test for a company, and I say it's going to be $20,000 to do a pen test of your network. I perform it, and they don't pay me. Well, what are my damages? Say I haven't given them the deliverable. I've done the kickoff, I've done the work, I have a document in my hand that describes it. I have not necessarily given them anything of value. I've done stuff. I've expended effort. I've expended time. I can sue them for damages, what it's cost for, if I've done the pen test or the workers have done the pen test, what it's cost me to pay them. What business I may have foregone because I did that. Or I can sue them for specific performance. Give me the money. Or if I've done a contract for something like, I want a piece of gear, give me that piece of gear that I have requested, or pay me damages. You can also, if you've realized the other side is not going to perform, you can do what's called anticipatory breach, which is, I will not perform either. For example, you find out that the company is not going to pay you. You can stop work. You can say, I have good faith to believe that they are not going to perform as they have done. I'm going to back out of my side of the contract. Or usually in the case of when you're doing information security work for a client as a consultant, it's something like you'll have a cooperation clause in the contract, because you can't do a true black box pen test, right? You have to know things like, what is the scope of your environment? What applications do you run? What sub-businesses do you run? You want to get information. You want to necessarily ask them questions about things. If they don't cooperate at all, like, I'm not going to give you an IP list. I'm not going to give you a list of my domains. Or I'm not going to give you a subject matter expert to walk things through. Well, you can say that was a part of the contract. Without that, I can't do my job well. I'm backing out. So, that's contracts. And contracts will come back to bite us in a bit. Regulatory law. This is a bit more complicated, because this is no longer an agreement between two parties. This is when Congress, the President, love each other very much, and they create a new regulatory agency, which is established by the legislature, but it also has power from the executive branch, and this is a little bit of civics. A regulatory agency, such as, say, Health and Human Services, has given power by law to do things like regulate healthcare within the United States. On one hand, you should be thankful for it, because many of you will learn that HIPAA is not a dirty word. Some of you, if you are working for healthcare inside, HIPAA is the best stick you have to get what you want. I've seen this more than once at a healthcare organization where if you're a security engineer and you say something like, I would actually like to pay for Splunk, or I need this tool to do a thing, or we need enough Windows licenses to actually match the number of PCs we have. As I see a couple people smiling at me going, yeah, I've been there. And you say, it's a security problem. And you watch as your management goes, uh-huh. But if you use the magic words HIPAA non-compliance, all of a sudden payment, purchase orders get signed. So it's a great stick to use. However, you can't overuse it. I had a friend once try to use it for something like, it's HIPAA compliant for me to have a better parking spot. I'm like, that's a challenge. Let's see how that works out for you. I mean, I once tried to, under FDA rules, I tried to order Ducati through my job by claiming that it would get me to work faster. And my boss, well, we'll just say my boss said no. Yeah. Also, trying to get it was Quantum that made tape drives that we were ordering. Like, can I get Quantum to buy me a bike and just deliver it and call it a tape library? And that's why I don't, do purchase orders anymore. So back to regulatory law. Sorry, I went on an aside. They're interpreted by courts, and the law can be changed by Congress. For example, HIPAA could be changed by next Congress. However, odds are, usually the legislature will not revisit laws very often. You have HIPAA, and then high-tech is like 7 years later, which affected some of HIPAA's requirements vis-a-vis security. It takes time for the legislature to make decisions. However, the regulatory agency itself promulgates rules based on those laws. So if you're thinking in sort of a IT governance space, the law is like the policy, right? Policy documents are usually unchanged, vague, high level, as in data that is sensitive should be appropriately protected. Right, that's a great thing to reach for. What does that mean? What do I have to do as a system engineer or as a sysadmin or a network grunt? What controls do I have to put in place and maintain in order to meet that goal? Well, someone gives me a set of standards and hardening guides that I can follow, right? I can't figure out what adequate security is, but I can definitely apply these patches, turn off these services, and limit users, right? That's easy. That's a checklist I can follow. So regulatory agencies generate regulations, such as 45 CFR 160 and 164 Part A and Part C are the HIPAA security rule. Some of you are nodding, and others of you, well, you'll learn. They can be changed by Health and Human Services on a 90-day basis. They can promulgate new rules and completely change what they want, as long as it matches back to the underlying legislation. So they will still not change things quickly because they want to have sort of predictable, they want to give predictable rules for entities to follow. They're not going to change things willy-nilly unless they're worried about something, unless there's a change in regulatory focus. And predicting regulatory focus is kind of a big chunk of my job nowadays, which is how is Health and Human Services going to change the audit guidelines by which covered entities are forced to do? How does Health and Human Services make you follow HIPAA? Well, they can fine you. They can fine you for non-compliance. They can also, in some regulatory schemas, they can bar you from the market. The FDA's biggest power for mishandling clinical data are filing false clinical data for drug effectiveness and drug safety is they can bar you from the market. That's great that you spent $1 billion for that drug. You can't sell it here. Have a nice day. Oh, and by the way, the shareholders are going to start calling you soon. That's a pretty big stick to threaten you with. However, most people want to follow the regulations. They want to know what they mean. So there's clarification and sort of prediction rules that are available. First is regulatory statements. The regulator, people in the regulatory agency may make statements about areas of focus, areas of interest. For example, SEC about 2 years ago said, we're going to, for entities that are regulated by the Securities and Exchange Commission, but not any of the other financial services rules under Gramm-Leach-Bliley, they said, we're going to basically expect that any shop that falls under our regulatory agency has to follow the NIST cybersecurity guidelines. And they left it at that. And, you know, my then consulting shop got a lot of calls, like, how do we follow these? Well, we're going to assess you, we're going to, you know, kind of walk you through what these requirements are, and 9 times out of 10, it's like, adopt a policy kit and follow it. But how do we know which one the SEC likes? Well, we watch and see if they're making any statements. We watch and see if they've published guidance. Sometimes, like, for example, Health and Human Services publishes guidance. They publish the audit guidelines for the Office of Civil Rights audits that they're doing. It's now in phase 2. It's basically saying, these are how we interpret our rules for you to do a thing, which is really nice. It gives you more color about how am I supposed to interpret this rule that says I should evaluate encryption to protect data. Everywhere? At rest? In transit? Only on some systems? What? And you look at the audit guidelines and go, oh, this is much more specific. So you can use that to follow and come up with how you govern your IT infrastructure. Going further to be, if you're in the, my job is to secure these things, is to say, this is what HIPAA requires, anything above it is gravy, anything below it is, well, a gap. We have to remediate it. But that gives you kind of much, much better marching orders than, say, just the legislation. So, criminal law. This is both the least and most fun part, because we joke about how you go from being a pen tester to a criminal. I'll give an example in a bit, but violation of criminal law. You have fines, you have imprisonment, neither of which is very much fun. How are they interpreted? Well, laws are passed by legislatures, and then numerous court cases will come and better define what that means. An example that comes to my mind is the Wiretap Act, 18 U.S.C. 2511, that says it is unlawful to intercept electronic communications while in transit. Does an email on an email server, if you pull that from storage, is that a violation of the Wiretap Act? And for years, every court case said no, because it's in storage, however temporary. It might, when it's on the wire, it's a violation. So if you use a packet sniffer to recreate that email, grab all the packets, knock off the headers, drop it back, there's the email, that's unlawful. But if you grab it from the mail spool, it doesn't violate the Wiretap Act. And that was good law for a bunch of years, and then First Circuit changed that a couple of years ago and said, no, clearly that's interception as well. Have a nice day. But it's interpreted by courts to say, this is what we think the law means, and a savvy lawyer can read the court cases and go, this is how I think it's going to happen, how your case is going to fall out later. So you can make a pretty good prediction about how a law is going to affect your individual practice or what you're trying to do. So I'll give an example. It's Computer Fraud and Abuse Act. This is a lot of commenters have said fairly nasty things about this law. I'm probably one of them because it is rather vague. It is, this is a subset of it, to access a protected computer. Definition of protected computers, it's used in banking or by the US government or is involved in interstate commerce or communication. So can anyone think of an example of a non-protected computer under this example? And I think the only one is like the TRS-80 Model 3 that's in my basement, powered off, right? Like every one of us has a protected computer in their possession. Because this is a computer, and it is involved in interstate commerce and our communication. So accessing it without authorization or an excess of authorization, that's vague, right? Like, for example, if I go to a website and I view the website, that is accessing said website. That's accessing a protected computer, right? Because it's a internet web server is involved in interstate communication. I am accessing it by hitting the website, and I'm getting information from it. Go to index, I pull index.html. I've obtained information from that system. What if I don't click on a link to get to that page, but instead manually write the URL? Is that unauthorized access? Who here thinks it isn't? Who here thinks that is, like, if you write the URL by hand, is that without authorization? Okay? I wrote an amicus brief for Weave, so I'm a little familiar with them. Yeah, you had to manually write them.
You had to manually write them. So you wouldn't click to get them. However, at the end of getting to those pages, there was the full records of AT&T's users. And those pages were for all intents and purposes unprotected. There was no user password, there was nothing. And that was not the do as far as I know.
Nope. He was convicted on that. His appeal was on venue. He could still be recharged. So it actually was, you could still argue it's unauthorized access. Even though the hacking he did was manually type a URL. Actually ran like a Python script, I think, to get them.
The whole point is that in AT&T's perspective, those links were not offered to the user. So they didn't say this is how it operates. In Congress, as far as I know, you're only allowed to access the things that are presented to you. So this is what I'm giving you, part of my back. I cannot go look in any of the other comments.
That's the problem. This is vague, because if I send you that link, I'm not AT&T, but I'm sending you a link back to the AT&T iPad website, that may be unauthorized access to AT&T's web server. So that's why this law is rather vague and kind of dangerous, because it shouldn't be unlawful. You should know when you're violating the law. If you get, the analogy I come up with for this is, if you get pulled over by a cop and the cop goes, "Do you know what you were doing?" and you say, "Actually, no, I don't." And the cop says, "Well, like, one, I'm not dating you, so I'm not, if you really cared, you know what you did wrong. But secondly, you want to have clear rules on criminal law. Yeah. Yeah. No, because the definition of protected computer it's not necessarily that what we in law call a term of art. The protected computer is defined as anything used in interstate commerce. So it doesn't actually require protections. Now, protections may give you an idea that this is unauthorized access. If I require you to enter a username and password to get in, well, clearly I'm trying to exclude you if you're not an authorized person. But this law is still vague, and this is why it's a little bit this is why it's a little bit dangerous. So how does this affect you as an InfoSec person? You're likely to be under a bunch of contracts as it is, right? You are working as a pen tester for a company, and you have a non-disclosure agreement, you have an employment contract, you have a statement of work with your with the test target. You are attempting to follow regulatory compliance. You're probably trying to ensure regulatory compliance for your client, and you also want to stay out of jail. So I'll give this as an example. Pen tester John, and if anyone gets the reference, I'll give you a point. No one's a friend of Duncan. No one likes Duncan Muentz. Okay. Check out Duncan Muentz talks at Gurkon. They're awesome trolls. So pen tester John is hired to pen test A, B, and C over at E Corp. He gets shell on D, which is a system not in scope of the pen test, but still owned by Evil Corp. He obtains healthcare information while pen testing system D. What legal action can pen test John be afraid of? He's violated the contract, right? Because he agreed I would test A, B, and C. D is right out. Do not touch, cannot has. He may have violated the Computer Fraud and Abuse Act because he has accessed a protected computer without authorization and obtained information from it. He has obtained PHI. Question is it a HIPAA violation? It may be a HIPAA violation for E Corp if it is not securely held. But Pentest John may not be regulated by HIPAA. So these are sort of how those laws affect Pentest John. And I realize I'm simplifying like hell, but no one needs a full-on legal lecture for this. So if Pentest John only hit A, B, and C, he hasn't violated the contract. He likely hasn't violated the Computer Fraud and Abuse Act because he has authorization to do all those pen testy things to A, B, and C. Which is why it's scary. When you do a pen test and you have that scope document, often fighting over what that scope means. And you want a very, very defined scope because you want to know what's safe and what isn't. And I have run over scope once or twice, and many of you will as well. It's figuring out, before you do anything dangerous, violent, validate scope. That is the easiest, that's a simple thing to do before you waste time and risk liability. So I'll give a second example. Developer Ann. She takes a job at Evil Corp as well. She signs a contract with a non-disclosure agreement and a non-compete. And she develops a specific application for E Corp. She then quits. She wipes the drive of the work laptop to show that there's no evidence that she took her code. She keeps the code base, and she sells all this stuff to a competitor of E Corp. What has she done? And try to walk through this. It's a contract breach. She's violated the non-disclosure agreement she had with Evil Corp. Now, this is not inherently criminal, but it can result in financial impact to her. She can be sued for the damages. She also violated the non-compete, which can bar her from working for the other company. It can also she can get sued for the damages. She also, though, has violated the Computer Fraud and Abuse Act. She wiped the hard drive. And this is one of those fun things. There's actually a case out of the Fifth Circuit out of Chicago called IAC versus Citron, where a guy is working for a real estate development company. He's using his work laptop to cite locations he would like to buy for his own purposes. He then decides, I'm going to quit, but he's sizing up these locations to purchase. He does a low-level format, overwrites the drive, hands it back, and says, here's my work laptop. Oh, by the way, I'm going to go compete with you. And the company he's working for sues him under the Computer Fraud and Abuse Act, saying, you have unlawfully accessed a protected computer, your work laptop, and destroyed information. And his response is, you gave me the laptop. Doesn't that assume authorization? And the court says, you weren't authorized to do that because you had decided you were going to quit. And your actions show that you retroactively lost authorization. That scares me, right? Because at what point do I lose authorization? It's not like I get a document that says, you can't do this anymore. It's my actions have made me unauthorized, have deauthorized me from allowing to do this because I'm not acting in the best interest of the company. So let's go back to Anne. She wasn't authorized. She might not have been authorized to wipe the drive. She wasn't acting in the interest of her employer with that laptop. She was acting in her own interests. Was that damage? Well, she's removed evidence. She's removed proof that that Evil Corp can show that she stole the code. So, throw this out for other questions. Hopefully this made some sense.
You were saying that he had implied authorization, but then lost it. While still being technically employed, he lost it because he had decided he wanted to quit.
He decided he was going to act against the interests of the company.
It was the action.
Yeah. Yeah. It's not just like I've decided to quit. It's you have now done actions that are adverse to the company. That if the company had known you were doing it, you would get fired for it or you would get sanctioned for it. I saw you had your hand up. Yeah. Uh-huh.
I don't know how things work with the American law, but as far as I know, the most important thing in such a case are intent and prejudice. You have to demonstrate that there was a malicious intent, and that there were damages / money loss at that standard. I mean, that's in theory because I believe that people should be prosecuted based on intent. Not everybody is able
I would agree with you. And actually, there was talk about reforming the Computer Fraud and Abuse Act after Aaron Schwartz's case, because there is the intent requirement under the Computer Fraud and Abuse Act is that you knew what you were doing. You did the act intentionally. Motive, what you intended to have happen, is not a part of it. So a lot of argument in the Weave amicus brief was the role that pen testers and independent security analysts have is that we are essentially consumer protection for the internet, right? We find vulnerabilities and we report them to, if we're, pure white hats, we then responsibly disclose them to the software manufacturer or the website to say, hey, we found this, you should fix it. The problem is that it is under the Computer Fraud and Abuse Act unlawful to pen test that website without that website's permission. And it matters not what our intent is. If our intent is pure good, where it's just, I'm looking for vulnerabilities. A friend of mine and occasional client, Sam Bone, does this, where he, by Google dorking, finds things like open FTP sites that are opened by pieces of malware. And one case was he finds an open FTP site at a hospital chain in Louisiana and says, I found documents in this unsecured FTP site that no password is required, and there's patient records here. Either someone's really incompetent or you've been pwned. And he goes and contacts them, and they don't take this the way any of us would, which would be, I would hope if you're in a sysadmin position and you get a phone call from someone saying, hey, I think you've been pwned, the answer should be, thank you, I'm looking into it, rather than, I'll have legal contact you, and if you say, and make threats. But they instead, it wasn't handled well. Technically, that could be a CFAA violation, because you are looking into a website, an FTP site that has patient information, has information that is potentially sensitive, but you don't have authorization. And while I might argue that a guest access FTP server is equivalent to saying, come on in, the documents are fine, the court may not agree with that. The court may say, you should have known. Just because it's open and available doesn't mean you can take it. So that vagary is kind of worrisome. But I can only explain what American law is now. I don't foresee Computer Fraud and Abuse Act getting changed significantly in the near future with like a motive requirement. So let me see if I understand the HIPAA right. You are authorized to do the pen test. You're authorized to. Okay, and so you can clearly go to the company that hired you and said, "I found this. This is bad." Your argument then is you find evidence of crime. Yeah, there's a. Now, whistleblower protection is usually used for if you are an employee and you go to a regulatory agency with insider information, your job is protected. This is a little bit different because you're wondering about criminal liability. There is a rule that says you generally don't have rights of privacy in evidence of crime. So this is often used for drug sniffing dogs. The idea that it's not a search because the dog will only alert if there are drugs in your car or luggage or whatever. There's evidence to show that this is not true. But the dog sniff cases run on the idea that if there's a magic wand you have that can only detect contraband, in this case, this evidence of crime, you don't have if it's truly evidence of a crime, you could go to law enforcement and say, I found this as a part of my pen test. I think you would be protected. It would it would depend on sort of not the magnitude of the crime, it would depend on your agreement with the company. You might still not get the money for the contract because you have violated the non-disclosure agreement. And, generally though, yeah, they might, I don't think they'd be able to sue you because you could defend on, I violated the non-disclosure agreement because there's evidence of a crime. And most of these contracts will have pretty much every non-disclosure agreement I've read has a cutout for, except to, obey other legal requirements, such as if you're subpoenaed, right? I have a non-disclosure agreement, but a court has said I have to divulge this information. I think you would have similar protections. This would probably be one of those very, very fact-specific, because it might be that evidence of a crime isn't actually evidence of a crime. For example, I think the hypothetical, I've had some odd coworkers and this is evidence of a crime. Yes, and this is a law firm. Of course they have evidence of a crime. They're defending somebody. It's not evidence that the law firm's criminal. It's that their clients are scumbags. Yeah.
Okay, so first, with respect to, let's say, if you want to scope, you accidentally compromise the law system.
Mm-hmm.
Worst case scenario, what is the recommended best course of action with respect to penetration test at that point in order to protect themselves, short of creating a paper trail?
Let's see. So say for example, say it's negligent, right? You've been hacking all night, your eyes are crossed, and you transpose two numbers. So instead of 53, I hit 35, and you compromise it. I think, yeah, this is one of those, sometimes it's better to walk away and not say anything. I think it depends. If it's a out-of-scope system owned by the same, if you're, yeah, then it's usually the better because you still have protection of, look, I thought I was operating in scope. I inadvertently did this because I'm thinking of the one I've done where it was out of scope was, they had a DNS redirect, and they gave me the domain names, not the IPs. So I didn't know about the redirect, nor did the person who hired us. And the redirect went to a box in Amazon's, in AWS, and, boop, owned it. I'm like, oh shit. Because I'm like, look at the IP. I'm like, this is who owns this piece of shit? I'm like, oh shit, it's Amazon's. Oops. And we just we found this, sorry. And it wasn't because it was a web app. The web app itself was what we were pen testing. I'm like, technically it's still owned by the company. We just said this installation of this was broken, and we didn't mention that we hit it. We just assumed. But if it's clearly someone else's, like in my case, it's probably best to stop as soon as you notice it and just sit tight. Stop hitting that, because odds are, unless you've done something to it, right? If you just poked it and went, oh, it's got a vulnerable version of the application, I got shell, just stop, back off and go. Not installing code, not dropping an interpreter shell into it, not changing anything, not leaving a touched file or anything like that, and just go okay. And that way, if you didn't continue exploiting it. So it's evidence to show if in case you do get prosecuted, it was a mistake. Sorry, wrong house problem. Not I got all this and then continued attacking. Because even though the law isn't clear, it's often the narrative that comes with it. If you are a pen tester, and what do? You break into boxes because you're paid to do it, and that's all you do, and you have a history of just that's what you do. Hitting the wrong box, that's a different story than Weave, who, if you've read anything he's written or interacted with him, comes across rather abrasive. You know, he's a troll. And what I think convicted him more than running the script was the post-breach chat logs, where he talks about selling them. And he mentions that as a joke, but it's one of those, this is a bad fact that makes it more likely for a prosecutor to say, this is the story I have to sell the jury. Bad guy. Versus pen tester who couldn't shoot straight. The second narrative is a lot easier, because I've talked to people who have done this, who have said, I saw a vulnerability in fill-in-the-blank site that they had access to. One is a case, the state they were in had a website dedicated to paying taxes, and they realized that in the URL was their social security number. It's like, a problem is, of course, he calls up a friend and goes like, I think you're in this too. Can I borrow your social security number to test it? And that's a sign of true friendship. Like, hey, two penders like, hey, what's your SSN? I just need it for a thing. And they test him like, yep, I pulled up all your records with just your SSN. Didn't require a username, didn't require a password. And in the code, in the URL was also, you could toggle between T and U for something. He's like, T. Oh, wait a minute, that's the taxpayer view. What does the A stand for? Admin. Boop, there's the admin page with no authentication. He's like, so he writes this up and sends it to him. It's like, oh. I mean, he's being a good citizen, right? And he didn't get prosecuted, but he did get because the person who first responds to his call was like, thanks for showing me that. That's really good. I'm gonna, I'm the project manager in this. I'm going to give it to the engineering team, and they're going to fix this. And then a week later, it's, hi, we're law enforcement from that state. We'd like to ask you some questions. And evidently, the way they said that gave him the fright, and he hired an attorney. And it's one of those like, when did I stop being a good guy and started becoming a bad guy? Even though your motives may have been clear, we come across as weird to normal people, right? Like, who here has lockpicks in their possession, right? And it's like, well, of course, like, who doesn't know how to pick locks? Who doesn't rifle a desk because it's there? Who doesn't do things like, go through a TSA checkpoint and you watch the screens to see what they're doing? That's my natural curiosity, as it is most people in this industry. That comes across as strange. That comes across as malicious to normal people. And we need to not be, and also a lot of pen testers, especially junior ones, will try to be as what I call ookly spookly as possible, which is like as outrageous, like I owned all the things. And we think it's funny until you try to explain that to 12 people who couldn't get out of jury duty. And then it's like, yeah, you're not cool anymore. You're, Yeah, just check, yeah.
What's your opinion on, building the weapon versus wielding the weapon? Let's say I build a website, checkyourwebsite.com.
Uh-huh.
I put all the, W3F and all the stuff in it, automate vulnerabilities. Like a premium model, you can do a basic vulnerability scan for free, and you can get a more premium vulnerability scan for $5, whatever. And let's say that you come along and using my website, my service, to have a paid website. How does that work?
Okay, now the first question is, your testing model, like, do I have to authenticate that I own the website you're testing?
No.
Okay, so we can pick any. Here it gets into a potentially tricky subject, which is what information are you allowed to gather from a website that is authorized, right? Presumably, The actual content on the index page. Clearly that's, like, I've put it out there for it. I would argue that some things like TLS headers and other things you would do to fingerprint an operating system and a web server would be there as well. Yeah. Mm-hmm. Okay. Right. My knee-jerk reaction is possibly both, because you have put a system out there that can be used. You intentionally built it there. And the analogy I would, if I was a prosecutor, use is, you were the one who put the loaded pistol in the playground and left it there. Right? Because you put a tool that is very, very dangerous and said anyone who wants to use it can use it. Yep. Well, no, because if I put the tool that you have to use, right? I download Kali, I use it. All I've given you is the tool that you have to build and use. If it's just a website, that the website itself, your systems go out. There's a slight difference there, right? You're doing Kali as a service. If it's just download Kali and there you're just running a gun store. So you're giving people guns and saying, now go to the playground. I think the difference is you're giving more power to the if you're running the gun store, you're giving more power to the user. If you are instead leasing the tool there that you can use the website to attack another site or to obtain this information from another site, you have, I think, a bit more liability. I'm sorry, yes. CFAA is very vague, and I've read enough stuff that says it was deliberately so to catch, because the belief was hackers are so super powerful that you can change your behavior to get through loopholes in laws. And the problem is that is what we call obeying the law. If you don't break the law, oh, that bastard, he did exactly what it needs to be to not break the law. Yes, we call that being law-abiding. But no, we need to have these vague laws to catch those wily hackers. And like, I don't have a bug strip in no, it's bad. Like, I don't have bear traps in my house to catch people. You shouldn't have this very, very broad space that you can trip over. Yeah. Okay. Right. Mm-hmm. Usually there is an invention disclosure clause that you may have negotiated. Also, many state laws limit how much the company can demand that every piece of intellectual property you come up with is theirs. So then it's presumably, like, they taught you something then, or they showed you something, and you at least got a good idea, like, oh, you can do that. Huh, I can monetize it over here. Then you're using some of their intellectual property. So presumably then, if they've had a half-competent invention disclosure clause, there's a kernel of your new invention that is theirs. So you would they would have some rights to it that you would either have to license to you, or they might own it. So it kind of comes down to that invention disclosure clause and the state law. So it falls into that depends on a lot of, like, very specific things, depending on the state you're in or the country you're in, and that invention disclosure clause, as well as what kernel you took from what they were doing. If it's just know-how, right? You learned how to write faster code. That might not be as protectable as some very, very specific thing that hasn't yet been released. So it falls down to a couple of things that are much more specific.